I think we're now ready to resume. Mr. Squires.
My Lords, yes, we were asked to look at a number of things over the short adjournment, which we've done as quickly as we can. We did look at the 2008 recommendation that my Lord referred to and the Matthew case. If I may, we think there may well be, particularly in the recommendations, things that we would want to draw the court's attention to. I wonder if we could do that overnight. Or so we'll send a note as soon as we're able to, after the hearing is finished.
Well, so let me just think. James will be on his feet later this afternoon. Can I just ask, Sir James, in responding to Mr. Squires, is it going to cause you difficulty if you have to wait until tomorrow morning to get his note on the 2008 recommendations?
My Lord, I'm sure it won't. I know Mr. Squires well enough to know that I'm not going to get a diatribe, so I'll get something short and crisp, I imagine, and I'll be able to pick that up tomorrow morning if that's convenient.
I mean, basically, the only reason I've raised the matter is that it's a Council of Europe document which the UK has signed up to, which says a great deal of what we've seen in other documents, but may be more directly relevant simply because of its source.
But although that struck us as well, and generally for the submissions I've been coming to make about what it means to treat a child, respecting a child's inherent dignity, there's quite a lot here about how one expects children in prison to be treated. So if I may,
yes, and it deals specifically with solitary confinement, and it also deals with the defence of lack of resources.
Yes, well, it does. It does. And so we'll try and make sure we get something back today. So
yes,
have it when he wakes up in the morning. We also said we try and find a case, my Lord asked, in which a direct finding by the CPT of inhuman and degrading treatment was picked up, and we have. I say we, my Industrious Junior has found while we were speaking a case on the papers of that sort. It's just an example. It's Nazarenko, which is in it's tab 30, page 3091, and it's a.
Mr. Squires, I'm sorry, Mr. Squires, it's a little bit distorted. I'm not getting the page reference.
Oh, I apologize. 3091.
Thank you.
It's a prison conditions case. We don't necessarily say the facts are analogous, but what you will see at paragraph 97, 3109, is a CPT report concerning conditions in Ukrainian prisons, and the conclusion at the end of the quotation that it amounts to inhuman, degrading treatment. That description of conditions, not related to this particular applicant, and you'll then see that picked up at 3120 in the court's analysis. It describes this applicant in similar conditions to the ones the CPT found, and then in the middle of that, or 2/3 of the way down that paragraph, it says, in common with the observation of the CPT, etc., to similar conditions, the court considers detention of the applicant unacceptable. Of this kind amounted to degrading treatment in breach of Article 3. So what you see, again, we don't say that they're saying they're bound by it or anything like that, but one sees there an example of that kind of finding. My Lords, I think just before the short adjournment, I had dealt with the Ramirez-Sanchez case, and we made the point. That's, I think, the first case that refers to the exceptionality test. Use only exception only after every precaution has been taken, and one sees in that case the specific picking up the use of that word and finding exceptionality. One finds the same in the Dennehy case. This is Mr. Justice Singh, as he then was. I don't think we need to turn it up, but it's Supplementary Authorities, tab 10, 2299. And Mr. Justice Singh paragraph 109, refers specifically to RMAD 212, which is where we saw the exceptionality test repeated. And then in 125, paragraph 125, in his conclusion, he goes through the various RMAD criteria, and on exceptionality, he describes the claimant as being in an almost unique position in the prisons of this country. She poses an exceptionally high risk to others, including other prisoners. And you can see why he reached that conclusion from the facts. I think he explains she's only one of 2 women on a whole life sentence. She's a serial killer, and specifically paragraph 82, the prison authorities found a credible escape plan involving her and 2 other prisoners, including a plan to seriously assault or kill an officer, cutting off a finger to fool biometric systems. A prison uniform was discovered in the laundry room. And you can see why that led Mr. Justice Singh to conclude she posed an exceptionally high risk. And say that again is the application of that test. The person has to be exceptionally dangerous or there be exceptional dangers to them in order for adult solitary confinement to satisfy Article 3. And then the final case, where again, no breach of Article 3 was found, a decision of this court in Shahid. Again, the court, paragraphs 1 and 3, refers to the exceptionality of the case. There, it was the exceptional threat posed to Mr. Shahid because of the nature of his crime and its notoriety. And our submission in relation to that is, of course, we say there is a strict necessity test, and this is very close to it. But there are 2. But even if we're wrong on that, there are 2 limbs to our ground 2, which is the court urging failing to apply a strict necessity test or an exceptionality test. And on any analysis, one does have to look for what the measure does have to resort to exceptionally and only after every precaution has been taken. And that's, even if that isn't strict necessity, which we say in effect it is, that is the adult test. And our opinion is that that test was not applied and would not have been satisfied in relation to this child. Well, that's the adult solitary confinement case. The final case I want to show you briefly, it's another restraint case, but it's in the domestic context. And again, it highlights the particular vulnerability of children in the court's analysis. It's the case of
Mr. Squires, I wonder if I could ask you a question just before you move on from your explanation of the 2 limbs of ground 2. Can you just explain to us why exactly you say either a strict necessity test or an exceptionality test is not complied with here? Because I thought that the factual findings were that AB needed to be separated from other inmates for his own security. So are you talking about something different from the fact of segregation from other inmates?
We are, my lord. We say we don't dispute that separating him from other inmates may well have been necessary, indeed strictly necessary, for his own protection. But what has to be strictly necessary, used exceptionally, is solitary confinement, which we say is quite different. And that's, we went through the various bodies that discuss it. All of them recognise you may need to separate him. But what is unlawful, we say, what was unlawful in this case, was subjecting him to conditions of solitary confinement, i.e. locking him in his cell for 23 hours a day, providing no or very little meaningful human contact. It's that constitutes the solitary confinement. And it's that we say has to be shown to be strictly necessary. And that wasn't, as we're saying, it's not disputed, as I understand it. Now, we set out at the end of our printed case, I'll give you the reference, to show all the reasons why we say a strict necessity test or exceptionality test was not satisfied. And as I'm saying, that isn't disputed. So I think it's the solitary confinement needs to be shown to be strictly necessary and exceptional.
Yes, it seems to me that if one's putting it in that way, the point raised by Lord Reed on the the 2008 recommendation about relevance of resources might be very significant, because, as it seems to me, what you're really saying is that he should have been provided with a richer environment in terms of adult input and provision of educational materials and so on. But the findings in relation to that were that there were resource problems in respect of meeting that aspect of the case. So are you going to help us with sort of submissions focused on the relevance of resources or lack of resources?
My Lord, I will deal with it. I was going to deal with that briefly. What we say in relation to that is what the finding of Mr. Justice Ousley in relation to particularly education, from the failure to provide with 15 hours a week of education, was not a lack of sufficient resources. I can get the quote. It's essentially that not enough thought, effort and resources were put into it, was his finding in paragraph 31, which wasn't appealed. As a general matter, whether resources could or would not be relevant, we do have some submissions on that, but in this case, it's never been said the reason that he was kept in solitary confinement was a lack of resources. And you can see that because once the Howard League intervened on the 20th of January, you then have a meeting on the 24th of January and measures are then put in place. He does start to get kinetic education, educational provision, etc. So that's why we do say that whatever the legal position, which I'll deal with very briefly on resources, it is not said here. The first Court of Appeal said his resources would be relevant, but there's certainly no suggestion that the reason AB was kept in solitary confinement was there weren't resources. I say once it was appreciated what his position was, measures were put in place relatively quickly.
Yes, thank you.
Well, yes, I think I was finally going to go to the briefly, I hope, to the C case in the Court of Appeal, particularly because it's helpful to see how the international material again ties in to a case of this sort. It's 1161 tab 13. And this case concerns changes that were proposed to be made to the secure training centre rules, which is where children up to the age of 17 who are in detention can be kept. And the changes were to allow children to be restrained for good order and discipline. Previously, you could only restrain children if they pose some sort of risk to themselves or to others. The proposal was to allow restraint in secure training centres for good order and discipline. So a child refuses to go to their room, can they be taken effectively? Can they be restrained in that way? And what the Court of Appeal there finds, it says a strict necessity test, and we accept this as another restraint case applies, and the Secretary of State couldn't show it was strictly necessary in this context to allow restraint for that purpose. Helpful for our purposes, my Lords, paragraph 58, which is at 1183. And again, we do say this appears elsewhere, but here's the domestic court saying expressly paragraph 58 ties into what's saying in Bouillard, but then applied particularly to this group of children. We normally think of Article 3 as being extreme levels of violence, deprivation, or humiliation, but two circumstances have been identified as imposing special obligations to the state are that the subject is dependent on the state because he's been deprived of liberty and that he is young and vulnerable. And then it's set out how that follows through in Strasbourg jurisprudence in paragraph 59 at the end. The recognition of the particular vulnerability of this group of children, and therefore that's important when one's interpreting Article 3. Then perhaps I'll also just read paragraph 60 to 61. So this is an example, quite close analogy with how the international material is dealt with.
Can I ask you, Mr. Squires, another characteristic that renders people vulnerable and is important in this context is if they have mental health problems. Now, is that an aspect that's relevant in the present case?
Well, my lord, it is. I mean, he is also, obviously, the general principles apply to children, but he is a child who, in addition to his age, does suffer from serious mental health problems. You see, he sent those out and give some of the references to the medical reports.
Yeah.
And those, of course, are linked in this case to the reason he ended up not being able to associate with other children, because it's partly his shouting out threats, which a number of the doctors who saw him as assessed as being linked to his attention deficit disorder, hypervigilance.
Yeah, I see.
Stress disorder. So yes, we rely on that estimate of vulnerability too. Then 60 to 61, you'll see how the court treats another UNCRC recommendation. Again, it's a recommendation in relation to 37C, so it's the dignity provision. Notes Williamson authoritative view, and then expresses concern about how the Secretary of State deals with that. But what's important for our purpose is you can see a very close analogy. Again, a 37C being used to interpret Article 3 by reference to what the Committee on the Rights of the Child says here about restraint, particular types of restraint. And finally, the court in this case considered the restraint was at least prima facie degrading, what it would describe an infringement of human dignity prima facie, and then found it wasn't strictly necessary. One of the reasons it was found not to be strictly necessary, and this ties to the resources question that my Lord Sales asked. One of the reasons it was found not to be strictly necessary, one can see from paragraph 33 and the paragraphs before, and I'll give the court the context of this. This is page 1177 and 1178. And one of the things that was said in this case by the claimant was you don't use restraint to enforce good order and discipline in relation to children in LA, local authorities secure children's home, or lashes, it's described in paragraph 30. So one of the arguments was, well, if it's not strictly necessary to restrain children in those sorts of homes where children who committed offences are also sent, how can it be strictly necessary in a secure training centre? And you can see what the court said. One of says about the resource element there, paragraph 33, which is one of the points made by the Secretary of State. The Secretary of State identified various differences between LA, local authority secure children's homes, and STCs. And one of those differences was the worst staffing ratio at STCs. And Ms. Levy, who's there for the Secretary of State, you'll see what the response is to that submission. And what it is what you cannot do is set up a system in which resource constraints mean, in this case, children need to be restrained because you don't have enough staff. But in our case, and this does tie in, for example, to the findings made about the number of children, say more than 25% of the children in Feltham at the time were in solitary confinement. You can't set up a system in which there are insufficient resources to allow children to be unlocked for more than half an hour a day. But as I say, in this case, it wasn't said to be strictly necessary because of a lack of resources. That wasn't ultimately the defence put forward, and wasn't to say what Mr. Justice Ousley found. Turning now to the principles we say that one gets from these authorities and from the international materials. We say they're these. Firstly, we rely on the indication that while we tend to think of Article 3 in potentially extreme terms, what underpins it is respect for human dignity. That's the bullion, at least for our purpose. That's what we're relying on. And it's the particular strong link between concepts of degrading treatment and respect for dignity. Second, we get from these authorities and the various materials that the concern with dignity has a particular resonance when one's dealing with children, patients, other vulnerable people, and even more so when they're dealing with those people in detention. The courts in that context are particularly astute, and the state has special obligation in relation to respecting, not interfering with the dignity of those people. The courts will look especially carefully at any justification of measures that do interfere with dignity. Third, if one has a measure that interferes with, diminishes human dignity, that's when the strict necessity test is applied by the courts. But we would also say, if it's different, where the exceptionality test is applied in the adult solitary confinement case. And we've seen that that test has been applied. So the exceptionality test, adult solitary confinement, strict necessity test, restraint of children in custody, certainly restraint of patients. And we've seen, I've drawn your attention to at least what's said about the seclusion of patients. Now, we accept that the authorities, at least on strict necessity, rather than exceptionality, have been, at least from what we have found, restraint cases. But what we do say,
having difficulty. I'm sorry, Mr. Squires, I'm having difficulty hearing you because you're moving around a little bit and some of the sound is distorted. It's particularly important I should hear these submissions, I think.
I do apologise. Is the rest of the court having trouble hearing me? I can try and. So I'll try and speak up and more.
Thank you very much. Sorry to trouble you.
No, I apologise. We recognise that, at least on a strict necessity test, the authorities have been restraint case. But what all of them stress is the reason they're applying that test is the link with dignity. And the question then is, does the sort of solitary confinement we've seen in this case interfere with engage dignity? And we of course accept that 10 minutes of restraint, even for a short period.
Yes, this may be an appropriate point just to raise another question with you, because I think we've been shown authority that human dignity is a value that underlies the whole of the convention. And I wondered about the interaction of Article 3 with Article 8 here. I mean, it's perhaps unfortunate. We're just asked to look at this case through the prism of Article 3 because of the way the appeal is framed. But I did wonder whether a lot of the points that you're making, one would also expect to be made as finding a home in the convention under Article 8 in terms of the rights of children under Article 8 to develop their private life and so on. And I just wondered what you had to say about the relationship between Article 3 and Article 8, if there is any in the scheme of the Convention.
It's certainly right that Article 8 is also underpinned by a concern about, or one of the aspects of Article 8 has different aspects, but one of them is concerned with dignity. I suppose that and so in that sense, there's an obvious relationship between the two. I suppose the difference in the Article 3 context will be that there can be much more minor infringements of, or much more what feels like much more minor interferences that will engage Article 8, whereas we accept it does have to reach a higher level to get to the Article 3 threshold. And so that's why we do rely on the specific vulnerabilities of children in this context and all of the different materials that go
Certainly.
into it.
But could I just ask you this? I mean, in the context of Article 8, in the particular form of the complaints that you make in this case about the regime being provided to AB not being sufficiently rich in terms of human interaction, provision of educational resources, and so on. In Article 8 terms, one might expect that to be analysed in terms of positive obligations under Article 8, where, of course, the considerations are similar, but not necessarily identical to cases of interference. And I was just wondering why, if that's right, there would be a significant difference of approach when one moves into analysis of the same essential features of the case in terms of Article 3.
I suppose the difference would be, and this may be the difference between the strict necessity test and an ordinary proportionality one. In Article 8, for example, we would have to accept that one could look at resource constraints as you could say, well, we are putting you in, we're not providing you with these things because we want to put our money elsewhere. One can't say that when one is faced with an Article 3 case. It's either you have to show it's strictly necessary. You can't say it would be we decided money should be placed in some other pot. In answer to my pot, in answer to my question about the gateway in, if you like, I think that because of that difference in how the necessity test applies, one also has, I say, the higher burden. It's a greater infringement of dignity to get into the level of an Article 3 breach. And that also ties in, we say, why in fact all of these bodies actually say it should be absolutely prohibited. Solitary confinement of children, which anything that merely engaged Article 8, it will be hard to imagine a situation where one would say you should never do. But that is what we see the overwhelming view in relation to the solitary confinement of children. So in that sense, it's a greater, higher level of, and maybe it actually that interferes with, infringes dignity in a way that Article 8 sort of engages. If that's.
Yes, thank you very much.
Well, as I say, the question or the ultimate question for the court, at least on this part of the case, is does holding a child in solitary confinement in this way infringe the child's dignity? How do we expect what we consider to be a way of recognising, respecting the inherent dignity of a child, what Article 37C of the UN Convention on the Rights of the Child speaks about? And our submission is that we say this should certainly be seen as akin to a restraint. Obviously, one is comparing different things. If one thinks about subjecting a child to a 5-10 minute restraint, serious as that is, as compared to days being locked in a room with nothing to do but watch television, we say, in terms of dignity, again, whether one does it as a comparison or simply saying both are matter that infringe a child's dignity. And then it does tie in there with all of some of the points we raised this morning about how we think children should be treated. And we've seen a range of different things, including the YOI rules, recognising rights to education, recognising rights to be to a programme of activities, rights to physical education, none of which apply to adult prisoners. All of that is part of what we think of as treating a 15-year-old in a way that is appropriate, in a way that respects their dignity. And we say, conversely, locking a child in a room for 23 hours a day for that length of time with little or nothing to do, almost no meaningful human interaction, at the very least, triggers a strict necessity test in the same way. That goes to the issue of dignity. And as I say, but in any event, it also, if it means something different, requires last resort exceptionality to be applied. And we do say, if one then seeks to read the UNCRC and the UNCAT treaty provisions as interpreted, as understood by the responsible bodies, if one says, well, we should read those in harmony with Article 3 and take account of the CPT and all these other groups, all of them say it should never, children should never be placed in confinement because of the potential risk, because that is not how children should be treated. Our submission is that avoiding a conflict, reading in harmony at the very least, requires recognise dignity is engaged in an Article 3 sense here, and therefore, at the very least, that a strict necessity test applies. My lords, that's the issue on the appeal, because as I said, it's not challenged, it's not disputed. We set out in some detail 129.
Yeah, I'm so sorry. Just one further question rising out of this point on Article 8. Might it be said that Article 37C of the CRC has a field of coverage which overlaps between Article 3 and Article 8? In which, and if that's right, why does one just look at the commentary on Article 37C as telling one where the boundary is for Article 3 purposes?
Well, the only reason I accept one could certainly look at it in an Article 8 context. The reason we said it applies particularly in an Article 3 context is that in an Article 8 context, any interference is always justifiable in principle, whereas what the Committee on the Rights of the Child, UNCAT, have all said is that under no circumstance should a child be placed in solitary confinement. So in that sense, they're thinking of this. I know they're not obviously doing a Strasbourg analysis, but they're thinking of it in absolute terms rather than in balancing terms, which is at least fits more naturally in Article 8. But we accept there may be some aspects of 37C that fall within and overlap with Article 8. But insofar as the Committee on the Rights of the Child says there should be an absolute prohibition, that feels very close to, or that appears to be a recognition close to an Article 3. You should never be doing this.
Yes, I see. Thank you.
My lords, I say you have my submissions, you have our submissions at 127 to 137 of our printed case, page 108, of all the reasons why we say had a strict necessity or had an exceptionality test been applied, it was bound to fail. It doesn't say that's not, that isn't disputed. I wasn't intending to go through those, but you'll see there why we say one couldn't satisfy the test if it had been applied. My lords, that's what we say about what is ground 2 of the appeal, the strict necessity. I can do briefly, I think in the last 7 or 8 minutes that I have, on the higher, which is it in fact per se degrading treatment? Is this something that should simply, it invariably Article 3? And the submission on that is, it's a relatively similar submission, but it comes from, it's very much grounded in what is said by the Committee on the Rights of the Child and the CAT about the international treaty, because I say our submission is in fact what those bodies say, as does all the soft international law and recommendation and domestic recommendations is it should be absolute solitary confinement of children. And the question then is, if one is then reading, and if that is the most authoritative view of what those conventions require, which we say it should be taken to be, we would say the higher way we can put our case is to say that in order to read those conventions in harmony with and avoid a conflict with, which we accept is what take account of when we're looking at international treaties, we say it ought to be, or certainly an argument made that it ought to be that's the per se threshold. These international treaties referring to inhuman degrading treatment and referring to dignity have suggested that children should never be held in solitary confinement. We say it is not reading that in harmony with Article 3 to say, well, it's a different test in relation to Article 3, and that applies particularly to the UNCRC, which is regarded as the lex specialis for rights of children, and particularly 37 children in detention. So if one is reading that in harmony, Article 3 in harmony with those provisions, the question will be, why should those provisions, and particularly the ones that refer expressly to inhuman and degrading treatment in one treaty, mean something different in another treaty, and read them in harmony and say they should be interpreted in the same way. But as I say, if we're wrong about that, we certainly say that at the very least, reading them in harmony requires recognising the particular vulnerability of children and at the very least a strict necessity test if one is going to ever place children in solitary confinement. We'll kind of check if my lords, unless I can assist further, those are my submission.
Thank you very much, Mr. Squires. We'll turn then next to Ms. Gallagher, who appears on behalf of the Equality and Human Rights Commission. Ms. Gallagher.
Thank you very much, Lord Reid. Just give me 1 moment. Thank you. I appear on behalf of the Equality and Human Rights Commission with Mr. Adam Wagner. And may I say at the outset, the Commission is very grateful for the opportunity to intervene in this case, raising as it does such important questions concerning children in the criminal justice system. The Commission's written case appears in Core Volume 1 at page 160, and the order granting permission to intervene is at page 56. And of course, I say at the outset, we stand by our written submissions, we stand by everything in them. But today, in the short time I have available, my lords, I wish to draw upon 2 issues in particular from our written case. Firstly, the interpretation of Article 3, fact sensitivity and strong presumptions, which is addressed in Section C of our written case. And number 2, the use and relevance of international materials addressed in Section B of our written case. We don't intend to make oral submissions regarding the relevance of resources. The Commission on that issue supports and endorses the appellant's approach to the issue and has addressed it in writing at Section G of our written case. I do also intend, to the extent possible, to address a number of issues which arose in questions this morning, including, in particular, questions from my Lord Reid regarding the CPT and the very recent questions raised by my Lord Sales regarding the interaction between Articles 3 and 8 of the European Convention and how that's factored in. Before I start my submissions, I just wanted to indicate the route I propose to follow. I wanted to start by drawing attention to the factual backdrop with reference to the agreed facts. I then wish to turn to the issue of strong presumptions and fact sensitivity. I then will turn to the issue of the CPT materials and Lord Reid's questions earlier, and more generally, the use to which international materials can be put. And then finally, I want to turn to the interaction between Articles 3 and 8. And throughout, I'll be making submissions on how those issues apply in the circumstances of this particular case. So to start, regarding the strong presumptions issue, I'm intending, my lords, to give you references rather than turning materials up, just given the time I have available. I've started a little early, so I realise I'll need to finish by shortly after 15:10. So the key references to the strong presumptions issue in the written cases are in the intervener's case at section C, paragraph 17 onwards, commencing at page 168, in the respondent's case at paragraph 54, page 141, and at 79 to 91. And the appellant doesn't expressly deal with this in their written case. The Court of Appeal at 72 of its judgment, which is in Core Volume 2, page 205, concluded as follows. The interpretation to date given to Article 3 in cases such as Ahmed and Dennehy is that Article 3 calls for a highly fact-sensitive inquiry into all the circumstances of a case such as this to see whether the high threshold in it has been crossed. And the court accordingly stated, we do not consider that there are any bright lines or presumptions in this context. Now, the Commission's submission, my lords, is that the Court of Appeal in its analysis erred. It conflated the appellant's per se argument, what is now before the court as issue 1, essentially that solitary confinement of a child is inherently inhuman and degrading, and Article 3 does not always require a fact-sensitive inquiry into all the circumstances. It conflated that issue with the question of strong presumptions and dismissed both. And in the Commission's submission, it was wrong to do so. Now, given the running together of those two different issues, the Court of Appeal erroneously proceeded on the basis that the operation of a strong presumption was precluded by the need for a fact-sensitive analysis. And on the contrary, as I'll show you, as the Strasbourg authorities make clear, strong presumptions of a breach of Article 3 are an analytical tool deployed by the European Court of Human Rights over a long period of time. And the Commission's case is that it is precisely the sort of fact-sensitive analysis that gives rise to a strong presumption of a violation, which it is then for the respondent to rebut. Now, in similar vein to paragraph 72 of the Court of Appeal's approach, the respondent's written case highlights at paragraph 54 that the strong presumption argument is not expressly addressed by the appellant in his written case, but the respondent states that he'll address it in any event because of the intervener's submission. However, at paragraph 79 to 91 of the respondent's case, again, the respondent makes the same error and conflates the per se issue with the strong presumption issue. And that results, as in the Court of Appeal, with a flawed analysis. So, in brief summary, to set the scene before I turn to the cases, the Commission advances the following propositions regarding the case law in this field. First, strong presumptions are a well-established analytical tool in Strasbourg Article 3 case law, including in respect of detention conditions. And the Court of Appeal's finding at paragraph 72 that there are no presumptions in this context, the respondent's submission to the same effect, is simply not correct. Secondly, the use of a strong presumption is not in conflict with a fact-sensitive analysis. On the contrary, the strong presumption arises from the factual circumstances. When certain factual features are present, a strong presumption arises for the state, in this case the Secretary of State, to rebut. Third proposition is that the case law makes clear that the respondent's submission to the effect that solitary confinement is not hard-edged enough to found a strong presumption is not correct. The Commission submits that when you examine the overcrowding, cell size, personal space cases, despite the need for a nuanced factual analysis, strong presumptions nevertheless apply, and no proper distinction can be drawn between those cases and the present one. And in any event, it's clear that at the very least, certain aspects of AB's conditions of detention are hard-edged, to use the respondent's phrase. In particular, to give an example at the outset, the absence of minimum 1 hour exercise in the open air, which is a factor repeatedly cited as a minimum bare standard in the Strasbourg case law. And in respect of the facts of this case, the Commission will submit in summary that a fact-specific analysis here leads to the conclusion that there's a strong presumption that AB has been subject to inhuman and degrading, or at the very least, degrading treatment in violation of Article 3, which falls to be rebutted. Such rebuttal is bound to fail given the facts, but in the alternative, as we've put it in our written case, even if the court declines to conclude that a strong presumption applies, nevertheless, there's a breach on the merits. So turning to the Strasbourg authorities, my lords, in summary, over the past 16 years, since 2004, there have been in excess of 100 strong presumption Article 3 cases, 127 of them in total, commencing with the case of Tateva and Bulgaria, which you'll find in Authorities tab 40, that's from 2004. And it includes some authorities which postdate the Court of Appeal's judgment in this case, which we cite in our case at 20. Tateva concerned injuries in detention, and I don't ask you to turn Tateva up. I just wanted to give you the cross-reference to it. That is a case concerning injuries in detention, and at paragraph 48 of Tateva, the European Court of Human Rights said, echoing the language we often see in other contexts, such as Article 2 cases concerning the investigative obligation in relation to deaths in custody, the events in issue lie wholly or in large part within the exclusive knowledge of the authorities. As in the case of persons within their control and custody, strong presumptions of fact will arise in respect of injuries occurring during such detention. But those cases concerning injuries in detention and strong presumptions in Article 3 now apply, it's clear, in a wider range of cases concerning conditions of detention. And the first such case that I want to turn to is the case of Ananyev and Russia. Now that's in Authorities tab 24, and it commences at page 1641, and it's in Primary Authorities Bundle 2. Could I ask you to turn that up and to start at page 1685 under the heading Compliance with Article 3. And what you see there is that at paragraph 139 onwards, the court addresses the general principles, and I note, so I don't need to return to it, at paragraph 142, that the court makes a point of referring to the need to take account of the cumulative effect of conditions of detention, as well as of the specific allegations made by the applicant, which is particularly important here. Paragraph 143 to 148, the issue of overcrowding, which was the key issue in that case, is then dealt with. And at paragraph 148, the court describes the operation of a strong presumption. So it sets out certain key features, the absence of which indicate a strong presumption that the conditions of detention amount to degrading treatment. And the factors in question relate to cell size. Now, while we're in the case, can I just ask you to look down at the bottom of that page, 1687, to paragraph 150, where the court makes reference to outdoor exercise. And my Lord Reid made reference to this issue earlier, and Mr. Squires, Queen's Counsel, also made reference to this point. So paragraph 150, the court says, of the other elements relevant for the assessment of the conditions of detention, special attention must be paid to the availability and duration of outdoor exercise and the conditions in which prisoners could take it. The prison standards developed by the CPT make specific mention of outdoor exercise and consider it a basic safeguard of prisoners' well-being that all of them, without exception, be allowed at least 1 hour of exercise in the open air every day, and preferably as part of a broader program of out-of-cell activities. The standards emphasize that outdoor exercise facilities should be reasonably spacious and, whenever possible, offer shelter from inclement weather. You see that at paragraph 150, and it cites in the footnote the second general report of the CPT. And the court has frequently observed a short duration of outdoor exercise limited to 1 hour a day is a factor that exacerbates the situation of an individual whose freedom of movement is constrained. And my lords, earlier on in this judgment, the international materials which lead to that reference at paragraph 150 about the minimum 1 hour can be found. And given time, may I just give you the core references? It starts at page 1659 in the report, paragraph 55, and there's a summary of many of the key standards which Mr. Squires turned to this morning. There's a reference to the standard minimum rules for the treatment of prisoners, express reference at paragraph 55(21) to the requirement for all prisoners, child or adult, to have at least 1 hour of suitable exercise in the open air, if the weather permits. Paragraph 56, extracts from the second general report of the CPT in 2015. And paragraph 48, again, makes reference to the importance of outdoor exercise, minimum 1 hour of exercise in the open air. It's widely accepted as a basic safeguard, is what the CPT says, as a minimum standard, a bare minimum standard. Reference is also made to a Committee of Ministers recommendation from 1999, at paragraph 57, which makes the same point. And paragraph 58 also makes reference to the Committee of Ministers recommendation from 2006 on the prison rules and the amended European prison rules. And again, that includes the reference for your note is page 1663 going on to 1664. That includes an express requirement that every prisoner be provided with the opportunity of at least 1 hour of exercise in the open air if the weather permits. The next case on this issue, which I wanted to turn to, is the case of Mrcic and Croatia, a 2016 case. And Mrcic can be found in the Primary Authorities Bundle, Volume 3, tab 28, commencing at page 1836, for those of you who are using the electronic copy.
I'm afraid we all are. We don't have paper copies.
Thank you. I'm very grateful. And I'm sure the environment is too, Lord Reid. Thank you. That's very helpful. So I won't give the hard copy references. So Mrcic commences at page 1836. And the strong presumption issue is dealt with in particular at 1885. And again, what you see at page 1885, the heading is whether the allocation of personal space below the minimum requirement creates a presumption or in itself leads to a violation of Article 3. And you'll see at paragraph 116 that there's an acknowledgement that the court has not always been consistent on this issue. And there then is an analysis of the strong presumption approach at paragraph 119, 120, 121. And paragraph 122 is then the court's analysis on the approach to be taken. And this Mrcic case is a Grand Chamber decision. So it's a Grand Chamber decision on Article 3 relating to an adult and not relating to solitary confinement, but nevertheless an important case, we say, in your analysis in this case. So paragraph 122 refers again to the court's general principles in its Article 3 case law, and it cites reference to the Ireland and UK case about the minimum level of severity and the importance of a context-specific approach and fact-sensitive approach. It refers at paragraph 122 to the need to take into account the duration of treatment, its physical and mental effects, in some cases the sex, age and state of health of the victim. So all points which the respondent draws upon in his written case and with which the Commission agrees. Now, paragraph 123 goes on to say, the court's assessment whether there's been a violation of Article 3 cannot be reduced to a numerical calculation of square meters allocated to the detainee. But nevertheless, as you can see from paragraph 124, a strong presumption of a violation of Article 3 arises when the personal space falls below a certain level. And the court describes, the Grand Chamber describes that strong presumption test operating as a weighty but not irrebuttable presumption of a violation of Article 3. And you see that from paragraph 125. Now, while in this case, there's a couple of other key points of relevance to your analysis. So paragraph 127 addresses the methodology and standard of proof issues in conditions of detention cases. and it refers to the importance of being mindful of the objective difficulties experienced by applicants in collecting evidence. And bearing that in mind, you'll see at paragraph 128 at the bottom of page 1887 and over onto page 1888, the very bottom of the page, relevant information from other international bodies, such as the CPT, on conditions of detention, as well as the competent national authorities and institutions, should also inform the court's decision on the matter. That's the Grand Chamber at the bottom of page 1887, taking a view which is very different to the approach adopted by the Court of Appeal in this case, and highlighting why the materials which Mr. Squires took you to earlier should inform the court's decision on the matter. That's in stark contrast to the analysis that Mr. Squires took you through when, with a whole series of materials, the repeated mantra is used in the Court of Appeal's judgment to say, well, these are only recommendations, they're not dealing with the law. And Grand Chamber, paragraph 128, takes quite a different approach. It's also important to note in paragraph 128 that the operation of the strong presumption is addressed by the Grand Chamber. Once a credible and reasonably detailed description of the allegedly degrading conditions of detention constituting a prima facie case of ill treatment has been made, the burden of proof is then shifted to the respondent's government. Now, the respondent's argument in his written case is that in contrast to the present case concerning the child AB, Merchick entails a genuinely bright line, is the phrase used in paragraph 80 of their case. Now, it's quite clear from looking at those passages that we've just gone through at some speed that that's simply not right. That approach in the respondent's case of paragraph 80 fails to account for the Grand Chamber's reference to this credibly and reasonably detailed description of the treatment at paragraph 128. If it was a bare numbers game and the complainant only had to show detention in a cell of a particular dimensions, there'd simply be no need for such a description. But it is the overall description in Merchick, and in this case, that is key. So the Commission's submission is that rather than being contrary to a fact-sensitive analysis of a complainant's case, the strong presumption arises as a result of prima facie evidence of ill treatment. And once the complainant prima facie demonstrates inhuman or degrading treatment, the strong presumption arises, and the respondent state then has the onus of rebutting it, and by showing why in all the circumstances the treatment complained of did not amount to inhuman or degrading treatment. Now, critically, when we apply this to the facts of the present case, our submission is that a strong presumption should apply, that it's not rebutted, or in the alternative, there's a breach on the facts in any event. Now, we summarize salient features of the facts of this case at paragraph 24 onwards in our written case. That's at page EF 170. And may I highlight that they are all drawn from the agreed facts set out in the Statement of Facts and Issues, and in particular, paragraphs 11 to 14 and 25 of the Statement of Facts and Issues. So to summarize the key features here, which we say are particularly relevant, AB was a child, and a factor which, as my Lord Reid put it earlier, should be to the forefront of our minds in turning to this case law. He was also a child with particular vulnerabilities and an exceptionally difficult history. So he was a child with mental health difficulties and with learning difficulties. He had a statement of special educational needs. He was diagnosed with PTSD, conduct disorder, and ADHD, as you see from the SFI at paragraph 5. So you have a particularly vulnerable individual, both in terms of age and their learning difficulties and their mental health condition, who's then detained for 55 days in, to use the shorthand, solitary confinement. That's confinement in a cell, restriction to that cell for more than 23 hours a day, they're agreed facts set out in the SFI, departure from his cell for 10 to 20 minutes to retrieve ADHD medicine, departure from his cell for up to 30 minutes to shower, make telephone calls, and exercise. We appreciate that on 4 occasions in the 55-day period, he was allowed to play table tennis with a prison officer during the 20-minute period. But this is still a far cry, even on those days when he did play table tennis, from the minimum standard that we've just looked at, referred to in Ananyev, and referred to indeed also in the Merchik case about the importance of minimum 1 hour outdoor exercise for any prisoner, no exceptions. Breakfast, lunch and dinner were eaten alone in his cell. Mental stimulation in his cell was limited to a television, except when it was removed. And it's important to recall that it was removed on multiple occasions for punitive reasons. He had no access to education as a child of compulsory school age in breach of domestic law, a factor which of course has already been the subject of earlier findings in relation to Article 8. But rather like the question from my Lord Sales, it still is a very important part of the context when we look at the overall cumulative effect of his conditions for the purposes of Article 3. No access to a gym in breach of domestic law, again, part of the earlier findings in relation to Article 8, but very relevant when we look at the cumulative effect of his conditions. And critically, no access to psychological treatment or other intervention. And you see that from the SFI at paragraph 25, where he doesn't in fact have an assessment until the 13th of February 2017, outside the 55-day period. So our first and primary submission is that this is precisely the sort of credible and reasonably detailed description of the allegedly degrading conditions of detention constituting a prima facie case of ill treatment referred to in Merchik at 128, drawing upon the international materials and the Strasbourg case law, which we in our written case, Mr. Squires in his written and oral submissions, has highlighted. So our first submission is the presumption arises. It's for the Secretary of State to rebut it, and the rebuttal is simply not persuasive for reasons I will come to in a moment. So a breach of Article 3 should be found on that basis. But the alternative, as set out in our case at paragraph 32, is that even if you're not with us on the strong presumption argument, you should nevertheless find, and the Court of Appeal should have found, that there was a breach on the facts of this particular case when you look at the cumulative effect of those factors drawn from the SFI, summarised in our written case of paragraph 24. Ananyev, which we've just looked at, makes clear that account should be taken of the cumulative effect of conditions. And in brief summary, the cumulative effect of the restrictions we've looked at is that a 15-year-old boy with mental health difficulties and learning difficulties was kept locked in a cell for over 23 hours a day, for 55 consecutive days, for certain periods of which he didn't even have a television because it had been taken away as a punishment. And that was treatment to which a child was subjected, not only a child with a complex mental health history and particular vulnerabilities. And the severity of that treatment in our submission certainly meets the minimum standard in Article 3 for degrading treatment. And we also say it meets the minimum threshold for degrading and inhuman treatment. So the effect of those conditions was to prevent exercise for more than 30 minutes a day, and in reality less, because he had to shower, make telephone calls in that time, far removed from that minimum 1 hour requirement, which is a hard edge requirement, to use the respondent's phrase. No education, minimal meaningful interactions. The mental effects arise as a denial of education, restriction on time out of cell, the limit of stimulation to television during that period. And the consequence of that treatment, according to the Istanbul statement to which Mr. Squires took you earlier, includes serious psychological and sometimes physiological ill effects.
Now Lord Sales has a question for you.
Yes, Ms. Gallagher. I was just wondering how your paragraph 32 of your case relates to the grounds of appeal. It doesn't seem to be tied into the grounds of appeal, but just seems to be a general allegation not covered by the appeal.
Yes. So, my lord, that does fall within the first ground of appeal, issue 1, relating to the international materials and the use to which they're put. Our submission is that when you turn to using the international materials and applying them on the facts of this particular case, within issue 1, you should nevertheless find a breach. So that's our fallback submission. Now, of course, the strong presumptions argument, which I've just taken you to, was set out in the grounds of appeal. I appreciate it's not to the fore in the written case from the appellant. And I understand there's no dispute. The respondent's quite happy to deal with that issue and indeed deals with the issue in the written case. May I turn, I'm just conscious of the time, may I turn I'll take it a little out of order, just in light of the question which arose a little earlier, Lord Sales, from you regarding the interaction of Articles 3 and 8. And there is a relevant case which we can provide you if this would be of assistance. There are some cases in other contexts which look at situations where a violation of Article 8 is itself relevant to the Article 3 analysis. And this is an issue which has been looked at, for example, in a case called Alberte and Latvia. It's a 2015 case because it only arose about 10 minutes before I was on my feet, so to speak. I'm afraid we don't have it to hand immediately, but I can provide it to you. And in very short summary, I hope this is useful, Lord Sales, in light of your question. That case addresses the overlap between the positive obligations under Article 8 and the threshold under Article 3. Now, it was very different circumstances. It was a case involving a positive obligation to provide information under Article 8, which has been acknowledged by the Strasbourg Court in a range of circumstances. And the European Court of Human Rights held that the relative impact of Article 8 violative treatment upon the applicant in that case led to a finding that the distress thereby occasioned was of sufficient severity to meet the Article 3 threshold. The circumstances were very different. It was a case about the removal of tissue from the body of the applicant's deceased husband without her knowledge or consent, and the emotional suffering she experienced in consequence. But what the court said was that the violation of the negative duties protected by Article 8, given the lack of clarity in the relevant domestic law regarding consent and the absence of legal safeguards against arbitrariness, was a relevant factor when you turn to considering Article 3. And the court said, you get this particularly from paragraph 139 of the judgment, whereas she was not suffering from any prolonged uncertainty regarding the fate of her husband, in the sense that it had been resolved that his death had not been a result of a deliberate act. She'd faced a long period of uncertainty, anguish, and distress in not knowing what organs or tissue had been removed from her husband's body and in what manner and for what purpose this had been done. And the court at 142 considered that the violation of the negative obligations under Article 8 should be taken into account in context in its consideration of whether there'd been a violation of Article 3. And it concluded that the anguish she'd suffered here because of the Article 8 violative conduct was relevant to the Article 3 analysis and found there to be a breach of Article 3. Now, while the factual circumstances are quite different, it seemed to us, in light of my Lord Sales question, that it may be helpful. It also seemed, in light of my Lord Sales question, that Article 37C is critical, because Article 37C and the material which the court ran through in the Ananiev case makes clear that when you're looking at the cumulative effect of conditions of detention upon an individual who is subjected to solitary confinement, factors such as removal of education, lack of access to gym, restrictions on your contact with the outside world and with others, which are violative of Article 8, may be very relevant to the question of whether the threshold in Article 3 has been crossed. So our submission is that there is a clear connection and a need to look at both of those issues. I wanted to turn...
There was something said about this in, well, I think at least it's implicit in the discussion in Shahid.
Yes.
Because in that case, we said that although the degree of suffering involved didn't reach the level required for a breach of Article 3, nevertheless, the interference with his personal relationships caused by very prolonged solitary confinement was disproportionate. It hadn't been justified. On that footing, there was a breach of Article 8 on the merits, as well as because of legal breaches, a breach of Article 8, but not one of Article 3.
Yes. Yes, I agree, Lord Reid, with that. And the reason I raised Alberte is Alberte is an example of where there's behaviour which you might think ordinarily would arise solely in an Article 8 context. It's about right to information, obtaining information about what's being done with your husband's body post-death. But in fact, the severe nature of the violation of Article 8 there was considered relevant when you then turned to Article 3. My Lords, in relation to the international materials, we've given you very full submissions in writing regarding the international materials, but in light of some questions from my Lord Reid this morning, we did want to turn in particular to the issue of the CPT reports and materials. So our submission has been throughout that the international materials are significant persuasive authorities. And again, rather like the straw man that Mr. Squires was referring to earlier, neither Mr. Squires nor the Commission have ever submitted that this material is binding as a matter of domestic law. The submission is that these are significant persuasive authorities. Now, in relation to the CPT materials and in relation also to the 2008 recommendations, which my Lord Reid raised a question on earlier, we say that they are particularly important authorities, and it's clear from the Strasbourg case law that they are considered particularly important, in the same way that the Strasbourg court quite often gives particular weight to other Council of Europe mechanisms. I note that in the 2008 recommendations at 80.1, there is again a reference to that minimum 1 hour outside exercise requirement for all prisoners, no exceptions. So again, that's a consistent requirement for adults and children, which you see throughout the materials. And there's also reference to the importance of the inherent dignity of prisoners. Now, in relation to the CPT, we have some reference from the papers before you, which we hope will be helpful. And there's 4 authorities in particular, which we ask you to consider from the Strasbourg case law on the importance of CPT materials. First of all, the Ahmed case, which is tab 23 or page 1565, where the European Court of Human Rights places heavy reliance on the 21st General Report of the CPT. And paragraphs 116 and 207 in particular are helpful. Note, while in that case, that Ahmed also places heavy reliance on the UN CRC, relying on materials including the UN Human Rights Committee, whose decisions provide interpretive assistance in relation to Article 3. That's at paragraph 175. The second authority to draw to your attention is Ananyev and Russia. And that's in tab 24, page 1641, where the court relied on the general reports of the CPT to provide evidence for factual conclusions and to assist in its interpretation and application of the convention to the minimum standards of treatment. See in particular paragraph 144, and note paragraph 150 on minimum standards in relation to outdoor exercise, and 153 on access to natural light and fresh air. Merchik, to which we've just gone, which is page 1836, tab 28, where the CPT's reference to sufficient freedom of movement was particularly relied upon, paragraph 133, and then Boyd and Belgium, to which you were taken earlier by Mr. Squires, tab 25, page 1714, where the court emphasised the need to take account of the vulnerability of minors and referred to that being affirmed at the international level with reference to both the UNCRC and the 24th General Report of the CPT, paragraphs 52, 53, 109, at pages 1728 and 1742. Also on the CPT point, my Lord Reid asked a question earlier regarding the CPT report on Cookham Wood, and that is tab 33, page 2009. That's a report from 2016. Now the CPT, I won't turn it up given the time, but the CPT in reviewing conditions in Cookham Wood came to the conclusion that there was inhuman and degrading treatment. We see that from paragraph 91, tab 33, page 2015. And in our submission, those conditions were identical to AB's, and in fact AB's circumstances are worse in some respects. So the conditions which are identical are single unlock, 23.5 hours a day detained, only stimulation is television. And AB, of course, had his television taken away at times as a punishment. So in our submission, that's a particularly important report, and one to which we say the European Court of Human Rights would give heavy weight, and one to which the Court of Appeal should have given significant weight but did not. So all of those points we say go to the Court of Appeal's error on this issue. The Court of Appeal said at paragraph 100, EF 210, that the CPT was making recommendations for the future and they would not necessarily have immediate effect. And our submission is that is an incorrect reading of those CPT materials, given the role of the CPT and given the weight which the European Court of Human Rights, including the Grand Chamber in Merchik, gives to CPT materials. I'm conscious we've given you quite a lot of additional detail in our written submissions, and I am asked to say if the Commission would be aided by any further written submissions on any points arising, we're of course very happy to do that. But given the time, may I just conclude by, in circumstances where we have the rather dystopian scenes occurring in Washington today, may I make reference to one earlier description by an earlier president. Just give me one moment. It just disappeared from my screen. I'm so sorry. Apologies for the technical failure. My learned junior has just given me his computer. So we did want, given the day that's in it with the inauguration of President of the United States, to highlight what was said a number of years ago by President Obama in the Washington Post, when he said, research suggests that solitary confinement has the potential to lead to devastating, lasting psychological consequences. It's been linked to depression, alienation, withdrawal, a reduced ability to interact with others, and the potential for violent behavior. Some studies indicate it can worsen existing mental illnesses and even trigger new ones. Prisoners in solitary are more likely to commit suicide, especially juveniles and people with mental illnesses. Now, the body of material which is before you, we recognise, has not been the subject of a detailed decision in the European Court of Human Rights concerning a child, precisely as my Lord Reid pointed out earlier. But it's clear from the material before you that the European Court of Human Rights approach to this issue would be to focus upon the particular importance of this being a child and to draw upon the international materials regarding why children are different, why children have particular vulnerabilities, and why individuals with mental health issues have got particular difficulties, and to apply that to the circumstances here. The Commission's submission is that the European Court of Human Rights in these circumstances would apply a strong presumption that there has been a breach of Article 3, certainly in respect of degrading treatment, and that the Court of Appeal's approach to that body of material and the clear and consistent material regarding the rights of children in detention was the wrong approach. It erred in law in so doing, and this appeal should be allowed, both for the reasons given by the appellant and for the reasons given by the Commission. Unless I can assist further.
I think not, Ms. Gallagher. You've given us a good deal of assistance, for which we're most grateful.
Thank you. And my learned junior has just asked me to raise one point, given a question earlier. Ground 2 of Mr. Squire's grounds of appeal, and I think the reference is page 28, yeah. Paragraph 54. I'm just asked to give you this cross-reference. Ground 2, I think it's in fact a response to a question from Lord Sales about how this fits with the grounds of appeal. It says at paragraph 54, if contrary to the above, the prolonged solitary confinement of children is not inherently inhuman or degrading treatment, the Court of Appeal erred in holding that on the facts of this case, there was no breach of Article 3. So in fact, that's squarely within paragraph 54 of the grounds of appeal and is a matter which should be considered by this court. Thank you.
Thank you very much, Ms. Gallagher. Well, we turn then a few minutes later, I'm afraid, to Sir James on behalf of the Secretary of State.
My Lords, this appeal, it's as well to reiterate, appeal on two narrow points of principle. Did the Court of Appeal take an erroneous approach to the international materials, and specifically should they have found on the basis of those materials that there is a hard edge rule that any prolonged solitary confinement, I'll come back to what those terms mean, of a child is in breach of Article 3. That's the first issue. The second issue is alternatively, should they have applied a test of strict necessity? So that if not strictly necessary, the conditions of detention of AB breached Article 3. There is no appeal on Article 8. And there has been no attempt by the appellant at any stage to seek to identify errors in the factual findings or to suggest that the Court of Appeal or the High Court between them were wrong in relation to the factual findings that they made about this individual case.
I'm sorry to interrupt you at such an early stage, Sir James, but you're laying out your stall on the basis that this appeal is about two fairly narrow questions of law. You've just heard Ms. Gallagher rely on paragraph 54 of the grounds attached to the application for permission to appeal, which you may want to say something about. I'm also just wondering about the broader situation here. And I suppose from the perspective of the Secretary of State, this case is primarily important because of these general questions that are being asked about the correct approach. If we are with you on those questions and the case then goes to Strasbourg, it is unlikely to be so confined. I'm wondering whether, I mean, it's obviously a matter for you, but and I know it's instructing you, but I'm wondering whether you want to confine this appeal here to these narrow points and take your chances in Strasbourg on an assessment of the facts, or whether it makes more sense to take a less narrow approach to the appeal.
My Lord, with that temptation dangled in front of my nose, I'm not necessarily sure I'm going to bite on it.
Yeah.
My Lord, this principally goes to the domestic appellate function. Of course, my Lord is right that when you get to Strasbourg, all bets technically are off because you can make whatever submissions you want to make about the facts that have been found by the domestic courts.
Yes.
We're very well aware the Strasbourg court is not a court of quatrième instance. So take the facts as found by the domestic courts, but the domestic courts do have a fairly well-established and principled basis on which you reach this court. And this court tends to act as a court of principle. My Lord, we're principally concerned about that. But we do respectfully submit that for all the fact that there may be a throwaway reference, as it were, of the kind that my learned friend has just referred to, there's been no attempt to attack as wrong any of the findings by the Court of Appeal, which itself applied, as you will be well aware, the traditional appellate standard of trying to assess whether any of the facts found by the first instance judge were wrong.
Yes, well, nobody has raised this point until now, but the unstated premise is that the assessment of the judge at first instance stands on a question of violation of a convention right, unless he has demonstrably erred in some way.
Yes. And it could be said in relation to the first instance judgment that he erred in one of two ways. If you were in the Court of Appeal, you would say either erred on a point of fact and he was wrong, that would be the test that would be applied. In fact, the Court of Appeal agreed with his findings. They went further than concluding he hadn't gone wrong. But you could also appeal on a question of principle. And to some extent, the same constraints and the same principled tests apply at the leap into this court of principle between the Court of Appeal and the Supreme Court. So, of course, my Lord, I mean, it's a matter entirely for you. I'm not seeking to put the court into a straitjacket that it doesn't want to be.
No, but when I don't know, if, for example, well, there are plenty of appeals involving the Secretary of State, where this court is asked to make a judgment on whether there has been a violation or not.
Yes.
And isn't simply confined to the question of whether there's a demonstrable error of law in the reasoning of the courts below.
My lord, entirely. I don't quibble with that principle at all, or that practice. My point is not that it is impermissible ever to challenge a fact in this court. Of course it is. But if you're going to do that, you challenge findings made by the lower courts as wrong.
Well,
So
it's a fact. If you're going to call the finding of a violation or a non-violation a fact, of a very special kind of finding of fact.
My lord, the ultimate question is a question of mixed fact and law.
Yes, yes.
It's open to you to challenge either the facts or the law.
Yeah.
But it's a bit rum, it might be thought, to appear in a court of principle like this without having sought to say that any of the findings of the lower courts was wrong, and then to invite the court to disagree with them on fact, even assuming that the principle you've raised have failed. That's the only point I make.
Yes. Well, I won't take up more of your time with this. You've made your position very clear. Thank you.
My lord, I'm grateful. And with that rider in mind, and with that caveat in mind, I was actually going to start with the facts. So just in case my lord decided that you were interested in that, we do submit that you should take, and in truth can only take, the facts as found by the High Court and the Court of Appeal, and they were detailed and comprehensive findings of fact. You find them particularly in the High Court judgment. I'm not going to give you page references to the High Court or the Court of Appeal's judgment, it would take too long, but the High Court judgment, paras 3 to 10 and 38 to 49 in particular, and the Court of Appeal judgment, 13 to 22, 37, and 112 to 148. And as I pointed out earlier, the Court of Appeal concluded that there was no reason to decide that the High Court had gone wrong. Indeed, it went further, see Court of Appeal judgment 142, and positively agreed with the conclusions and the overarching conclusion of the High Court. I was going to highlight, if I may, 6 particular features of the facts as important, recognising, for reasons I'll come to, that Article 3 requires an intensive focus on all of the relevant facts. Firstly, nothing was done at Feltham with the intention of humiliating or degrading AB. High Court 124, Court of Appeal 41.6. Secondly, no part of the period that we are considering constituted a punishment or a disciplining of AB. High Court judgment 124. On the contrary, the justification at all stages for the segregation was to protect AB himself from other detainees, a position which flowed from a series of shouted statements involving racist and or sexist abuse. See High Court, in particular High Court 39 and 125, and Court of Appeal 119, 121, 125, 129, 133, 141 and 143. So he was being segregated for his own safety and the safety of others, and that was the considered and constant justification throughout the period. And as the courts below also found, his behaviour made him a very difficult prisoner to deal with indeed. He posed a challenge on arrival at Feltham, as disclosed in the pre-sentence report, which made disturbing reading, as the courts put it, and which contained material that directly impacted on the threat that he posed to staff and other residents. High Court, paras 7 to 9. On arrival at Feltham, he was placed in single and then 3-officer unlock because of the risks as a result of his behaviour at Cookham Wood. It was not due to, quote, happenstance or malevolence, High Court, para 39, and a description of the racist and other inflammatory remarks that he'd been making, perhaps sufficient to give you the Court of Appeal references on that, 121, 127 and 129 in particular. They involved a series not merely of such remarks, but also of direct threats to staff and other residents. See High Court judgment 40, 43, and then 45 to 47. And linked to this point, this second point on the facts, linked to this point, attempts were made, moving him in particular between units, to integrate him into the prison. They were thwarted on each occasion by his own behaviour, putting others and or himself at risk. See Court of Appeal 127133. As it was put by Mr. Justice Ouseley in the High Court, I'm quoting from 139, he represented a very difficult person to manage in the YOI, and the YOI were always seeking to reintegrate him. Reviews of segregation were conducted, though it was accepted below and is accepted here that they were not done at the frequency that they should have been. High Court 127, Court of Appeal 137. The third feature of the facts relates to the physical conditions in which he was held. And those are the subject of particular importance in the light of some of the cases, including those which my learned friend has just taken you, with the minimum cell sizes and so on. But as to those physical conditions, no suggestion that any part of the physical conditions in which he was held breached or risk breaching Article 3. You saw the cell plan, Mr. Squires took you to that earlier. He had sanitation in cell, he had privacy screens, he had a bed, he had a desk, he had TV. No complaint made at any stage about the conditions of the cell, the facilities in the cell, the food, the sanitation, or indeed the healthcare. All satisfactory. See High Court judgment, paras 38 and 108. Fourthly, he was not kept in, quote, total solitary confinement. High Court 131 and 133, Court of Appeal 113. He was not left, as the Court of Appeal put it, to languish isolated in his cell. There were occasions when he was in cell for more than 22 hours per day for a period of days, sometime out of cell even then, and also acknowledged that he didn't have the education that he should have done under the rules. In mitigation, perhaps, 2 points on that. Difficult, particularly difficult perhaps, to provide education because he couldn't be left alone with a woman teacher. Court of Appeal 137 and 144. And also you need to bear in mind that although we are focusing on the initial period, and advisedly in the light of the way the appellant has chosen to put the case, in relation to education, as my learned friend Mr. Squires accepted this morning, once the point about education had been raised, there was a relatively swift reaction from the prison authorities leading to kinetic lessons and so on. So although it's entirely open to my learned friend to confine his challenge to a particular early period, at least that broader vista is relevant in considering education as a particular feature. And in this period, he had interaction in cell, both with prison and with social staff, High Court Judgment 134, and he was in contact with officers outside the cell, including the references to table tennis that you've seen. High Court 39 and 134, Court of Appeal 115, and he had throughout contact with his solicitors from an early stage, High Court Judgment 129. Fifth point I've touched on to some extent, his care was not abandoned. There was strong contemporaneous evidence to show that the authorities were taking the situation seriously and were motivated by a desire to make things better. Court of Appeal judgment sets out the chronology and the history on that, and that finding 115 to 140. There were regular social welfare checks. He received proper medical care. His mental health was monitored and cared for by a community psychiatric nurse, by a consultant psychiatrist and another specialist doctor. High Court 128, Court of Appeal 120. His behaviour was then considered by MDMs and multidisciplinary meetings, albeit again accepted throughout, not with the frequency required by the rules. But the point for Article 3 purposes is he was not being ignored. High Court, Paris 17. And he received, so far as education is concerned, I should have added it in earlier, he received an educational assessment on the 14th of December, High Court, Para 40. But that only then cut in, I think, from the 24th of, after the MDM meeting on the 24th of January 2017, after it was realised he had not been provided with education packs. High Court judgment, Paras 27 to 28. Sixthly and finally, there is no evidence that his mental health deteriorated or has deteriorated during this period. High Court judgment 128, Court of Appeal judgment 41.8. Whatever other pearls of wisdom may fall from the previous President of the United States, it might be thought that his expertise in this sphere is at the very least unconfirmed. But come back to the position in relation to AB, he was assessed by a social worker within 2 days of arriving in Feltham and was, as I say, seen by the community psychiatric nurse and was then reviewed by a consultant and associate specialist, 39 and 41 of the High Court judgment. And the psychiatric report that he himself adduced for the purpose of the proceedings from Hales and Adshead stated that he presented much the same as when I met with him regularly when he was at Cookham Wood, recorded in the High Court judgment at paragraph 74. And just to complete those references, as Mr. Justice Ousley pointed out at paragraph 79, Healthcare reported to Governor Knight that there had been no concerns raised about AB's restricted regime having had any significant impact on him. That's High Court, Para 79. So that is the factual context as I have accepted. There were some failings as was accepted below, but there were some failings, particularly in relation to the provision of education and the reviews. But it's that picture that falls to be assessed against the very high level of severity that Article 3 requires. Those are the introductory points I wanted to make on the facts. I wanted to turn then to the international materials, if I may, and it is as well perhaps to start as topic 1 with the Article 3 principles themselves as established in the Strasbourg case law. And they are long and well established in the Strasbourg case law and indeed the domestic case law applying it. And I draw attention in particular perhaps to 4 features of that Strasbourg case law and those base principles. The first point is that the threshold for Article 3, as has been repeatedly emphasised, the threshold is a high one. What is required is severe ill treatment. And that is clear if you have the Sanchez case electronically to hand at paragraphs 118 to 119 on page 3538. The sort of treatment that they are considering is described, and the sort of treatment dealt with in Article 3 is described perhaps most those two paragraphs, if I can simply. The threshold remains high in the prison context is clear from a whole number of cases. One could take perhaps the mafia cases in Italy, Messina in Italy, as an example, but no more than that. Page 3022, where individuals were held under very strict conditions there because of the threat that they pose. So it was a disciplinary thing or a protective thing in the broader sense. But they were held in relative social isolation, as it was put there. But the threshold is a high one, is the first of the points. The second of the points is that the ECHR mantra has been the same throughout. And you get it initially in a case as long ago as the ill treatment of the IRA members in Ireland and the UK, page 2731.
Were they IRA members?
Were they suspects? I wasn't making a point about that. I was just trying to describe the case, but
yeah. Yes.
The point I was really after was that this mantra is of pretty long standing, as you see from paragraph 162. Well, I apologise if I misdescribed them. That is withdrawn, as it were. 162 statement of. And that will be very familiar to all of the members of the court. It's a mantra that is repeated in almost every case under the heading general principles. And what that description of principled approach leads to, and what it indicates, as Mr. Justice Singh, as he then was, concluded in Dennehy at paragraph 99, page 2313, was that what is called for by that mantra is, as he put it, an intensely fact-specific inquiry, or fact-sensitive inquiry. So that's the basic principle under Article 3, and as you will see, what it does is to identify a principle that says you look at all the circumstances and then a set of factors to which the court is directed. And of course, any of those factors in their own right and or viewed cumulatively could vary infinitely depending upon the facts of individual cases. That's why it leads to the intensely fact-sensitive inquiry that Mr. Justice Singh referred to. The third proposition is that in the context of removal from association or segregation, the basic principled approach is no different. What is required is a fact-sensitive approach, examining all the circumstances, applying the mantra that represents the correct approach in principle. And we see that in particular illustrated in the Ahmed case, Ahmed and the UK, 1619, if you would, in the electronics. And just to put it in context, you'll see the nature of the assessment. They were here grappling in this part of the judgment with the vexed question about whether or not in the extradition context, the justification for wanting to move a prisoner to another jurisdiction to face trial and the threat that he posed in terms of terrorism could justify exposing him to the risk of ill treatment. Did that feed in or didn't it? And they reached the position, which again will be pretty familiar to all of you, the kind of halfway house compromise position, if that's the right way of describing the approach that Lord Brown put up in Wellington all those years ago, C177. But the point for present purposes is not that principle, but it's to identify the sort of key features that in the context of ill treatment of prisoners have been held to be relevant. And they list those in the bullet points at 178 on page 1619. Going on in the final 3 lines on that page to reiterate that all of those elements depend closely on the facts of the case and so will not be readily established prospectively and so on in an extradition context. But it's those sorts of cases that illustrate the sort of focus that is required, but nevertheless that it is an exercise that requires analytically the examination of all of the circumstances. And you get the same theme further on in the judgment when one gets into the guts of the decision in relation to Article 3 and detention on page 1625. You'll see the recitation of the Ireland and the UK mantra at 201. And again, the description of the general principles is by now pretty well familiar between 200 and 204. But you'll see the basic approach that is adopted to what they describe as solitary confinement at 208 on page 1626. And the passage I really want is paragraphs 208, 209. And perhaps if you read to the bottom of 210, so it's 208 to 210, if I could invite you to read those paragraphs as exemplifying the approach. My Lord, one can go there from there to Ramirez Sanchez, which is in the passage I want is at page 3538. And again, you see exactly the same approach. Look at the title at the bottom of page 3537, General Principles. You see all of the same descriptions that we'll be very familiar with at paragraphs 117, 118, and 119. The worry here was the length of time spent in solitary confinement, as one sees from 120 on 3539. And they're looking in the cases that they then examine at 120, 121 and following down to the end of 124. They're looking at cases as comparators, a bit like the Supreme Court did in Shahid when considering Ahmed, and indeed I think this case also, and the sort of periods that were being dealt with. And of course in Ramirez Sanchez, the period in question was 8 years of solitary confinement. And it was that period that led to the intense focus on the purpose and the safeguards and all the rest of it. And the duration and nature of the solitary confinement are picked up in the court's judgment at 131 and following on page 3541. See in particular 134. And then the analysis goes on in 136 and following, looking in particular at the reasons for keeping the prisoner in solitary confinement. You see that, for example, at para 137, 3543. And here, obviously, they're dealing with a dangerous prisoner rather than protected custody. There may well be differences between that and our position. They note at 140, having analysed the reasons why he was kept in detention and in solitary confinement for that long. 140, they look at the medical treatment that was available to him. Look at the finding at 141. The absence of any deterioration in his physical or mental health is highlighted as an important feature at 144. The absence of any intention to humiliate or debase is picked up at 147, final sentence. And then the conclusion that is reached in relation to the 8 years of solitary at 150 is that there's been no violation of Article 3. But what we get from this analysis in particular, and
sorry,
Mr. James.
Mr. James.
I'm so sorry, I was looking at the case.
My apologies. And perhaps if I could take you back to a point that Lord Reid raised, and that is that if this case goes to Strasbourg, the proposition is going to have to be that it was good medical treatment of the applicant, of the appellant, in his particular circumstances, to confine him in solitary confinement. And so there is a factual finding, you're quite correct, that he received good medical treatment, but I'm just wondering how far that will take you at a later stage.
Well, my lord, I think the point I'm really on is that all of these cases can be examined. What we're struggling for, what we're trying to identify, is the principled approach. The principled approach requires you to look at all the circumstances. Particular factors and features are highlighted as particularly relevant, including the length of detention and its relative nature, including medical treatment. And the point I'm really on is the point of principle. How do they go about doing this? Are they imposing hard-edge rules? Are they saying a particular length of detention will lead to a problem? No, they're not. They're looking at all of the circumstances, including medical treatment, on the basis of the facts found by the courts below and or any material presented in Strasbourg, no doubt. But the point I was really on in relation to the solitary confinement aspect of this is that they are treating even solitary confinement, which we've all been using as a shorthand, but Strasbourg treats it, see para 131 to 134 in particular of this authority, as itself a relative concept. They do not say, well, here's what solitary confinement means. It means, I don't know, 5 days, 10 days, 22 hours in a cell, and that's it. What they do is they look at all of the circumstances, including all of the circumstances going to what they describe as relative social isolation. And it's that contrast between relative social isolation and what they describe as complete sensory isolation, coupled with total social isolation, that they are particularly interested in. But what they don't do, even in relation to solitary confinement, is to say, here's a definition. If you fall on one side of it or the other side of it, it makes all the difference, whether by way of hard-edge rule or some presumption or strict necessity or anything else. What they do is they look at all of the circumstances, including those going to the nature and length of the confinement itself. And we respectfully submit that that is the correct approach. It is an approach which focuses on all of the circumstances, which eschews, even in relation to the concept of, in inverted commas, solitary confinement, hard-edge rules, hard-edge principles of the kind for which my learned friend has to contend. And we see that very, very clearly from Ramirez Sanchez, where the analysis is not, we're now going to look at this to see whether it was 8 years or 5 years, or to see whether it was 20 hours in the cell or 22 hours in the cell. And if it is, there's the hard edge rule. Even in relation to that, they look to see what the facts in fact are. And that approach, we respectfully submit, is also evident from the domestic case law. I think I was right in recalling that Lord Reid's judgment in Shahid and Scottish Ministers, see in particular para 31 at 1376, draws specifically and by way of comparison, leading to a conclusion of no violation of Article 3 in that case, on the Ramirez Sanchez case. Now, of course, Ramirez Sanchez involved a thoroughly dangerous terrorist, and Shahid involved a dangerous person also, I think, and both involved adults. So we'll come to the significance of children in 1 second, but there are differences. But in relation to adults, at least, the approach in Shahid exactly exemplifies the 3 core principles I've just outlined in action. And indeed, I think the comparison with the length of solitary confinement in inverted commas was critical to the reasoning of the court in Shahid. And you can see exactly the same reasoning and approach and exactly the same principle in action in the Dennehy case. Mr. Justice Singh, see particularly paragraph 100 at 2313. I'd invite you to turn it up now. But that case involved the segregation of a prisoner with mental health problems for 3.5 years. Again, no violation of Article 3. Well, I was just going to give you the headline of the 4th point. I may have to develop it further tomorrow morning, but the 4th one, I hope Lord Reid at least will be interested in, which is that it can be a relevant / thoroughly important factor in the assessment. It comes with a but, I'm afraid, but does not displace the mantra, does not displace the correct approach in principle. And that is so is evident from 3 cases in particular. I might think overnight about whether I need to take you to these, but in particular, Bouillard in Belgium, which you've seen, involving a 17-year-old, where his age was noted, I should add, as they put it, as a, quote, secondary consideration on the facts of that case, perhaps because he was 17 and was therefore quite high up in terms of the age range, illustrating that age itself, as we all are increasingly aware, is a relative concept. Paragraph 109, 1742 in Bouillard, Myeka and Belgium, Myeka and Belgium. Para 58 is a relevant paragraph at electronic page 2903. That involved detention of a 5-year-old without any parent or other person assigned to her for 2 months, but still a fact-specific inquiry undertaken to see if the detention demonstrated, as the court put it at para 58, which I've given you the reference to, quote, a lack of humanity to such a degree that it amounted to. That was in relation to a 5-year-old. And Guvec and Turkey, key paragraph is paragraph 90 and 91, page 2666, a 15-year-old kept in prison but with adults. So they were mixed together. That was the core vice they were considering there. What did they do? They applied Ireland and the UK. They looked at all the circumstances, including at the age, and they found a violation in circumstances which were, as you see from paragraph 91, when you get there, very extreme indeed. So illustrating both the Ireland and the UK approach and the extremity that the facts need to reach to surmount the Article 3 threshold. And that may be a convenient moment to break.
Yes, certainly. Thank you very much, Sir James. We'll adjourn then for the day and resume at 10:30 tomorrow morning. Thank you very much.